The community property question from February of 2003 is about as straightforward and easy a community property question as you can hope for. I don't think there's a single new issue presented here. There are a couple of different slants on facts that we've looked at variations of before, but nothing really new. Take a look at the call of the question. You know we're in community property, and you know it's pretty run-of-the-mill just from looking at it. Upon dissolution, what are Henry and Wanda's respective rights in 1. The lake cabin, 2. The painting, 3. The State X house, and 4. Wanda's professional education and podiatry practice? Answer according to California law. Well, we are all set to impose our source, actions, conclusions framework on these items, and by and large, that's going to be plenty. But as we'll see, there's one or two more issues present, including one that we have to deal with up front, quasi-community property. Go to the top of the question and let's review it quickly. In paragraph 1, the longest paragraph in the fact pattern, we see Henry and Wanda getting married in 1980 when they were both students at State X University. State X is a non-community property state. Shortly after the marriage, Henry graduates, gets a job with the State X engineering firm. They have their only child, and Henry and Wanda agree that Wanda will stay at home and quit her job. They buy a house in State X using their savings for the down payment, and they obtain a 20-year mortgage for the balance of the price. The mortgage payments are made from Henry's earnings. Title is taken in Henry's name alone. Okay, a classic setup for quasi-community property. Predictably, in the next paragraph, Henry gets a California job as an engineer, and the couple relocate to California with their child, and they rent out the State X house. In paragraph 3, Wanda has an uncle die and leave her an oil painting, separate property. It's worth $5,000, and a small cabin located on a lake in California, also separate property, very unambiguous, very simple. But read on. It gets a little bit more complicated. In paragraph 4, we learn about the events of the following year, 1993. After reading a book called How to Avoid Probate, Henry persuades Wanda to execute and record a deed conveying title to Henry and Wanda as joint tenants with right of survivorship. Wanda did so, believing that the only effect of the conveyance would be to avoid probate. Well, let's just stop for a moment. This is a variation on facts we've seen before, but what's different here is there is no indicia of fraud. We don't have anybody overreaching, manipulating, or lying to the other spouse. Here, years before this marriage got into trouble, the wife made a decision to change title in the property in order to avoid probate. And the mere fact that she thought the only effect of this would be to avoid probate is not going to require us, or even really allow us, to change the form of title. Next, in the following paragraph, in 1995, after 3 years of study that Henry paid for, Wanda obtained a degree in podiatry and opened her own practice. It's a successful practice because of her enthusiasm, skill, and willingness to work long hours, every one of which is a community hour. Henry works for the engineering firm throughout. In 2002, Henry and Wanda separate. They file for a dissolution of marriage. Wanda had the painting appraised. The artist has died and become more popular, maybe as a result. The painting is now worth $50,000. And then we get the call of the question. So we know that we're going to have to begin this answer with a brief preface, a brief introduction about quasi-community property. We'll have to lead with the facts about where this relationship was born and where it ended up living and where it's going to die, and how the California community property laws are going to apply. It'll be short and simple. It will not be a lot of meaningless boilerplate, and then we'll do the analysis. So please turn with me to the outline of issues. You'll see I indicate that there will be an introduction about quasi-community property. Then all the rest of the answer is very conventional, organized exactly the way that we've seen before many times. We start out with a lake cabin. We deal with the source. It's an inheritance. The actions, Wanda's executing the deed that will ultimately cause this cabin to be treated as community property. The painting is a separate property inheritance. It has been hung over the fireplace and it's appreciated in value, but neither of those facts are going to change the status of the painting. It's Wanda's separate property. And it got that way by inheritance, and it'll stay that way. Next, the State X house. The wages of Henry alone paid for it. Title is in his name alone. However, they moved to California. The State X house thus becomes quasi-community property. Finally, with regard to the education and practice, here we focus again on the same standard template. The source is community property earnings of the husband. Actions are the wife's industry and hard work. The practice is a success. The conclusion, because of the 10-year rule, the community property gets reimbursement and the practice itself will be deemed community property. Well, as I indicated up front, this is about as simple and straightforward as these questions get. So now, let's briefly look at the answer together, and once again, we will see just how important it is to weave the facts and the law together to reach a meaningful, substantive answer. Look at the very beginning of page 1, and you'll see I lead with the facts. I explain that this marriage started out in State X, and it moved to California, and thus community property laws will apply, and you'll see that those two short paragraphs contain more facts than law, but clearly indicate a framework of the analysis that will follow. Next, we turn to the lake cabin. This analysis is really very, very simple. We lead with the facts with regard to the source. It is initially separate property, even under California law. But next, Wanda executes this deed that converts the cabin to joint tenancy, and she does it to avoid probate. These two paragraphs of analysis may be the most important ones in the answer. Have a very careful look at them. I think this is a good example of legal analysis involving the facts. And I don't think that reasonable people can differ. I don't think that there's any reasonable way that we can consider this to be a separate property asset. But guess what? The California bar examiners thought there was plenty of wiggle room here, and candidates that argued persuasively that the mere fact that Wanda executed this deed isn't enough to convert this property into quasi-community property was deemed fair enough. So once again, even here, where I think there is a clear-cut correct answer, the examiners were looking more for analysis than outcome. I conclude that this cabin is going to be community property. Next, we turn to the painting, and here I think that we have some more pretty good analysis to look at. Not under source. The source is very simple and straightforward, and it doesn't take very long. But the actions are a little bit more subtle. She took the painting and hung it in the cabin after she inherited it. Now the painting is worth a lot more. Well, these facts don't change the status of the painting as separate property. I conclude it's her separate property. Next, we turn to the State X house. Here again, the analysis is a little bit in depth because we've got a fair number of facts to deal with. But legally, this is very simple. The source was wages of Henry, and the title was taken in his name alone. And for as long as they lived in State X, that was the property's status. But as soon as they moved to California so that the husband could take this nice engineering job, then it is a quasi-community property asset. So upon dissolution in California, either this will just be treated like community property, or there will be some set off with other property to allow for an equitable distribution of assets. Finally, we turn to the professional education and podiatry practice, and here, again, we're going over ground we've seen before many times just in this seminar. This is some of the most commonly tested material in the outline. Well, let's go through it. The source was Henry's community property earnings paid for the education. She got this practice in 1995 after 3 years of study. The education was paid for entirely out of California earnings of the husband. Therefore, it's a community property asset. And thus, the actions don't change this from community property. They further underline the community property status. The wife worked hard. She was skillful. The practice succeeded. All of it is community property. So we conclude, first, the community will be entitled to a reimbursement for Wanda's education. and the practice will be deemed a community property asset. Now, that doesn't mean we will liquidate the practice. In equity, Wanda will be allowed to keep it and to keep operating it, and the husband will be entitled to other property or a note for future payments as a set-off. And that wraps up a consideration of a very generic, standard California community property fact pattern.